Well, good afternoon if you're on the East Coast, and good morning if you're way out west. My name's Aaron Lacey, and you are listening to the Department of Education's Evolving State Authorization and Professional Licensure Requirements, which is part of the Higher Education webinar series brought to you by Thompson Coburn. And we are delighted today to be joined and co-sponsored by two sterling organizations that are related to one another, WCET and SAN. That's the WCET Cooperative for Educational Technologies and the State Authorization Network, which is a division of WCET. While folks are coming online, I'll go ahead and jump into the housekeeping. First of all, there is a Q&A widget there at the bottom of the platform. If you have questions during the webcast, we encourage you to submit them through the Q&A. We're going to try to answer these to the best of our ability at the end. So go ahead and drop them in, and we'll get to as many as we can. I'd like to note that a copy of today's slide deck is available in the resource widget, and we encourage you to download any resources or links you may find useful. I'll also note, as is often the case for those who've watched our webinars before, and is the case here, our PowerPoint includes live links in many places to underlying resources. So when you pull down that PDF of the slides that's available in the resource widget, you'll also be able to get access, of course, to those links and the related information. You can find additional questions to some common technical issues located in the help widget at the bottom of your screen. So if you experience any technical problems during the webinar, you can take a look there and see if you can get some assistance. You can also report those technical issues through the Q&A widget, and our producers are always keeping an eye on that just in case. Our webinar is approved for continuing legal education. Today's presentation specifically for all our lawyers out there is CLE accredited in California, Illinois, and Texas for an hour and a half of general credit, and in Missouri for 1.8 hours of general credit. Also in New York for 1.5 hours of professional practice credit for experienced and transitional attorneys. I don't know what that means. I'm not barred in New York, but I hope it's good. We award CLE based on attendance for the entire 90 minutes. Today's session is 90. So please keep in mind, if you're an attorney trying to get that CLE credit, to demonstrate your continued engagement by looking for the secret words that are going to pop up. We have 3 of them today. They show up in the form of a multiple choice poll, and we just need you to click on the right radio button to indicate that you're still there and you're still listening. So again, please respond, watch for those, please respond to them, because we want to make sure you get the full CLE credit. If you have any trouble for any reason, you can also always reach out to us after the fact. Finally, as we do with every one of these webinars, we have a post-webinar survey. We are deeply grateful to those who tune in and stick around and fill out the post-webinar survey. We get a lot of great ideas and feedback. So if you have a minute to do that, we thank you in advance. All right, with that being said, like I mentioned at the outset, am just delighted today. We have a couple of guest presenters with us. The first is the remarkable Russ Poulin. Russ is Executive Director for WCET. Again, that's the WCET Cooperative for Educational Technologies. He truly is an expert and leader, as it says on the slide, in the area of federal and state policies concerning educational technologies. So all that distance education stuff, and relatedly, all the policies and regulations in the world that are evolving around managing these types of technologies. Also of significance, Russ represented the distance education community. He's done so on federal negotiated rulemaking committees and subcommittees, but in particular, I wanted to highlight that he was a negotiator in 2019 for the, Russ, I'll ask you to correct me here in a second, but I think it's what the Accreditation, Innovation, and Distance Education rulemaking. I forget what the full title was, but it was the 2019 rulemaking that included significant discussion of state authorization and distance education issues. I'll also note that Russ is a cat person, and we've got a picture here of his cat Luna, which I think we can all agree has obviously been doctored using deepfake technology, which is exactly the kind of thing a cat person would do. So Russ, with that having been said, I was going to ask you here, if you have a second, just to give us a little overview. I know a lot of folks know who WCET is, but maybe just a little bit on the organization.
I'll do that and go through the organization soup here. And so our parent organization is WCET, the Western Interstate Commission for Higher Education, Regional Higher Education Compact with the 15 Western states and the Pacific Territories and affiliated states. They're focused on student exchange issues and higher education policies and services across the states. They started us in 1989 to focus on distance ed issues and distance ed and digital, and we expanded into digital learning issues. Our members are primarily institutions, and we have members from throughout in all the 50 states and a few in other countries as well.
Very good. Thank you, sir. And that is a nice segue to our other guest presenter panelist today, which is Ms. Cheryl Dowd. Cheryl, I hope you are well. Cheryl is a senior director of the State Authorization Network, SAN Network, and WCET Policy Innovation. So coordinates and works with Russ and others, serves the WCET membership in addressing emerging and special regulatory issues related to digital learning and post-secondary education. I'll just say Russ and Cheryl both in this policy world are two of the people I know, maybe the two people who most closely follow all of these issues. I know that's a contest. There are some others out there, but I'm always quick to call both of them and to follow the Frontiers blog and other materials they make available. I trade emails all the time with Cheryl and Russ because they are just so on the cutting edge, which is why when we decided to talk about this topic, we really wanted to see if we could get some time from them, and they were kind of offer it to join us on this webinar. I'll also note that Cheryl is a dog person, and you can see pictures of Piccolo and Hercules there to the right. Cheryl, anything you want to add about sort of the role of SAN in the world?
Sure. So thank you very much, first of all, for inviting us. And you've set the bar really high. So we hope that we can provide your attendees with really good information. So thank you. But the State Authorization Network is a membership organization. It's a separate membership organization from WCET. And we have approximately 900 institutions and agencies nationwide, except for Vermont, Kansas, and Hawaii. So anybody from those states, we're still looking to have those as part of our membership. But our goals and our mission is to address the interstate activities of post-secondary institutions and to help manage the state and federal compliance around those areas. So we do follow these issues that we're talking about today very closely. And so I'm really glad that he pointed out my dogs too, because I am here with my dogs. And so if you hear any barking, that is probably the light colored dog. He starts it, but he is fiercely protecting me. So I'm well protected. So thanks again for having us. Really appreciate it, Aaron.
My pleasure, and glad to have Piccolo and Hercules as well. Rounding out our panelists, we've got my colleague and friend, Katie Wendell, who's one of the attorneys here at Thompson Coburn and works in our higher education practice and has for, 13 or 14 years now, worked with institutions on a range of issues, but particularly those around federal, state accrediting agency laws and policy involving state authorization and distance education. In fact, Katie and I next week will be at NASAPS, where I'm sure we'll be maybe seeing some of you out there, some regulators, and talking about some of these issues. Katie, as always, I'm grateful for your expertise and that you could join. And I note that your dog person, you are a dog person, and that your dog is present. It's Yoshi. Although I have to say from the photo, Risky Business, I was thinking probably would have been a better name. So thank you, Katie, for being here. And then finally, I'm Aaron Lacey. I'm the chair of the higher education practice and work with schools on a wide range of issues and have the pleasure of hosting this webinar series. And those are my dogs, Louis, the greatest dog in the world, and Asher, the other dog that lives in my house. I'll just leave it at that. So here's the syllabus for today. The new rules taking effect July 1st, 2024, professional licensure program disclosures, the new PPA requirements, the devil in the details, and program integrity rulemaking. The idea here is the first three sections are going to go back quickly. I just want to set the stage. I expect that many of the folks out there know what is going on already, but I wanted to make sure to put up the regulatory language and talk a little bit about timing and specifically the requirements that we're looking at here. Our real focus in this presentation is the law that is becoming effective on July 1st, because our view is that's already on the books and that's what schools are having to contend with in the near term. But and then we're going to go into the devil in the details section, which is really the Q&A, where I'm going to pose questions to Russ, Cheryl, and Katie. And we're going to try to, all three of us work with schools and have been getting lots of questions from you all for the last 2 or 3 months. And so we tried to collect those questions. We also collected all the guidance, the tidbits we've gotten from institutions who've been talking with the department, from our conversations with the department, from our sort of read of the law and the Federal Register, et cetera. I will say as a disclaimer, and I'm sure most of you on the line know, the department, as of today, to my knowledge, we checked just 10 minutes ago, has not yet put out any sort of Q&A on this topic. If they had, it certainly would have been featured in this presentation. So we're going to do our best to pose and answer what we believe are a lot of the more difficult questions based on the information that we have to date. That being said, and in particular, if you're listening to a recording of this webinar after the fact, look, be on the lookout for the Q&A. I mean, once we get some guidance from the department, everyone, of course, will want to take a very hard look at that. And then finally, we're going to take a little bit of time just to talk about the recent rulemaking that was just completed, because it also addressed some state authorization and distance education issues. So with that being said, let's get moving. So when I talk about the rules that are taking effect on July 1st, 2024, there are several packages, actually. You've got the income-driven repayment plan rules from last July, this big financial value transparency gainful employment rule. As some of you know, we've done some coverage on that. And then there was another package of rules that came along right at the deadline of October 31st last year that covered various topics: financial responsibility, ability of benefits, administrative capability, and then finally, certification procedures for Title IV participation. And as part of that topic, the department proposed and included some language around professional licensure programs, programmatic accreditation, and state law compliance that really relates to your authorization to offer programs in certain states, right? And so in a sense, this became a state authorization, distance education type issue, even though that was not one of the sort of marquee issue areas that was being addressed during the negotiated rulemaking. That's the piece we're focused on today, because we know that it's creating a lot of consternation for a lot of institutions as they review these new rules and try to prepare for compliance. But before I talk about the new stuff, I want to take just a minute talking about these professional licensure program disclosures that were put into place by the Trump administration. These were the rules that were created pursuant to the rulemaking that Russ was involved in, that negotiated rulemaking back in 2019. And you've sort of been living with these rules already. And I want to talk about them because the new stuff that becomes effective July 1st in some ways relates to these and in some ways does not. And we thought it was really important to try to distinguish among the two. Among other things, these disclosure requirements sit in a completely different place within the law than the new PPA requirements that I'm going to talk about that relate to professional licensure, programmatic accreditation, and state closures. And we want throughout this presentation to keep sort of reinforcing for you all that while these two are related, they are sitting in different places in the law. To some extent, they act independent of one another. And as you're going to see as we have this conversation, you know, the department really did not perfectly harmonize them when it introduced these new requirements. So in some cases, the two don't always work together as well as we'd like them to. So the disclosure requirements that you've been dealing with since 2019 are part of the larger consumer information disclosure framework that is housed in 3468, 41, 42, 43, 44. This is the section of the regulations that details 43 specifically, 668-43 is the section of the regs that details all that, quote, institutional information. That's the name of the section that you all have to disclose to students or prospective students. And this includes a range of information, including, you know, costs of attendance, refunds, academic programs, copyright infringement, fire safety report, vaccinations. Every time the HEA gets reauthorized, special interest groups get a hold of this and start inserting some additional things, often that have no direct relationship to federal financial aid. And that's where in 2019, the department decided to move these disclosure obligations around professional licensure and programs leading professional licensure and certification. So again, we emphasize that the disclosure requirements are part of this consumer information framework. I also want to highlight and emphasize that the new rules that become effective July 1st did very little to alter these disclosure requirements. I mean, the revisions are really just a few little extra words, right? So it's important to appreciate that that disclosure framework that you've been dealing with for several years now really has not significantly changed except for one feature, and I'll get to that in a minute. But it is still the case, for example, that institutions have to determine the state in which a student's located at the time of the student's initial enrollment in an educational program, and if applicable, upon formal receipt of information from the student that the student's location has changed to another state. You also have that requirement in 600.9C, which is the state authorization requirement. So this obligation to determine location sits in two places in the law, here in the disclosure section and also in the state authorization regs in 600.9C. And that language has not changed, right? It's also still the case institutions largely get to fashion these policies and procedures pursuant to which you're gonna determine location at the time of initial enrollment. We're gonna talk about this in a little bit more, but I wanna emphasize that that language has not changed. It is still the case that if an institution has made a determination that a covered program, meaning a program that leads to licensure or certification, does not meet state educational requirements for licensure or certification in the state in which a prospective student is located, or if the institution has not made a determination regarding whether the program's curriculum meets such requirements, then the institution has to provide notice to that effect to the student prior to the student's enrollment. That obligation was put into the law in 2019, and it still exists today, notwithstanding the new stuff that we're going to talk about. And it is still the case that if an institution determines that a program's curriculum does not meet the state educational requirements for licensure or certification in a state in which a student who's currently enrolled in such program is located, the institution has to provide notice to that student within 14 calendar days. None of that has materially changed. Okay. What did change, and what you've probably heard about, is that for any educational program that is a professional licensure or certification program, and we're also going to talk in a bit about what we mean by that, but that satisfies this sort of definition, that it was designed to meet educational requirements for professional licensure certification. It's advertised as such. For any program in that bucket, an institution must make available a list of all states where the institution has determined that the program does and does not meet such requirements. You are no longer obligated under the law to produce a list of states where no determination has been made. By the way, you can. There's nothing that prevents you from still taking a three-list approach here. So you can still have a list that says, we've not made any determination. And we're going to talk a little bit later about why some schools might want to do that. But the legal obligation that has changed here in the entire disclosure framework, the only thing that has really changed is you're no longer obligated to produce a list of states in which you've not made a determination. However, and this is the big change that leads us into the new law, if an institution is not enrolling students from a given state, again, it's not obligated to determine anything regarding that state, but you can't offer the program to anyone in that state. So to be clear, if you said, hey, we're going to continue to maintain three lists, and I've got this professional licensure program, and I've got the do's or the does states and the does not states, and then I've got all these other states where we've not made a determination, you can't enroll students in a Title IV program if it's a professional licensure or certification program and you've not made that determination. That's one of the big differences here. We're going to get more into that because that's the new law. That's the lead into the new law. But again, the main thing I want to really emphasize here is these fundamental disclosure requirements and sort of the framework for the disclosure requirements has really not changed, except for this notion that you are no longer obligated to include a third list of states in which you've not made a determination. Okay, by the way, that brings us to today's first secret word. And if you were in or around St. Louis, you would know that there's a big ball game here today. It is that time of year where first pitches are all over the place. So the first secret word is pitch, as in throwing out the first pitch of the game on the first game of the year. So please select that word down below. I believe it is A, at least on my screen. So please click A, which is pitch, so that you can get your credit. I actually now these days on our new platform, I can see how many of you have submitted your responses. So right now it's telling me we're about halfway there. And I know you're not all attorneys, but would be delighted to get everyone who is an attorney enough time to, again, select the very first button there, which is pitch. I keep referring to them as radio buttons, but that's not a round button. I guess it's a sort of a square. So I probably need to change that. Okay, I think we've all had enough time, hopefully, moving right along. So now let's talk about the new requirements. And I'm referring to them as the new PPA requirements. And that is because, importantly, these new requirements are not in the consumer information section of the law. They are not in the section that talks about state authorization. They are in the section that talks about your program participation agreement. Some of you will know this, some may not, but an institution's program participation agreement conditions its participation in the Title IV programs on, quote, compliance with the provisions of this part, the individual program regulations, and any additional conditions specified in the program participation agreement that the secretary requires the institution to meet. So if you've never seen this document, it is literally a contract. It's the contract between the school and the U.S. Department of Education. And at the end, there's a signature block, and your president has signed, and the Secretary of Education has signed. This is the fundamental contract between the school and the federal government. And Section 668.14 of the regulations articulates all the things that have to go into that contract. So the new requirements that we are talking about are requirements that have been inserted into 668.14, which again means they are new fundamental tenets in your contract with the department. In other words, when you sign that contract, you are certifying to the department that as a condition of being in the programs and staying in the programs, you will meet these requirements. So it's a little bit different. This isn't just a disclosure obligation, right? This is actually a fundamental obligation that goes to your eligibility to participate in the Title IV programs, and it is part of your contractual relationship or contractual obligation with the feds. So the department has inserted 3 new ideas into the PPA, right? And by the way, you may not all get, in fact, I can almost assure you, you're not all going to get new contracts when come July 1st. When the law changes like this, it's just understood that anything that moves into 668.14 is now, part of your contract with the department. The next time you would get a new PPA, say as part of recertification or something like that, those new provisions would show up. But trust me, you're obligated to comply with them as of July 1, as if they are part of the contract that you physically have on your desk or that your president has. So the idea is they've inserted three new obligations. These obligations have to be met in covered states in which you offered your program. And they don't, the department doesn't define this term. This is a term I'm making up for purposes of this presentation. But I wanted to make sure this is an initial sort of threshold piece to understanding how this works. So when I say covered state, I mean any state in which you are located, in which you have a physical campus. Any state, if you're talking about distance education, and we're not exclusively talking about distance education, clearly, right? So it's anywhere you're physically located. Any state in which students enrolled by the institution in distance education or correspondence courses are located, as determined at the initial enrollment in accordance with 34 CFR 600.9. Remember, that's that same test. It shows up in 2 different places, but that's the state authorization part of the law. It says you got to decide where students are located at the initial time of enrollment. So, if I'm an institution, I'm physically located here in Missouri, which is where I happen to be sitting, and I have an online program and I'm enrolling someone and they are physically located in Michigan at the time of initial enrollment, then what they're saying is Michigan for me is now a covered state. Missouri's a covered state because I got a campus here. Michigan's a covered state because I'm enrolling a student in a distance education program who is physically located in Michigan at the time of initial enrollment. And then finally, any state in which a student who enrolls in a program on or after July 1st attests that they intend to seek employment. And we'll explain why the department included this later. But the point is, so if I'm enrolling that student who's physically located in Michigan, but that student signs an attestation and says, I am physically located in Michigan at the time of initial enrollment. I'm enrolling in your distance education program, but my plan is to work in New York. Then I'm, instead of satisfying Michigan's requirements, now the notion is my professional licensure program needs to satisfy the requirements in New York, right? Because the student has attested that that's where they intend to seek employment. These are all covered states. So when you're thinking about, what states are we concerned with when we talk about complying with these new standards, these are the states. Right. Okay. So what are the 3 new requirements? First of all, professional licensure. So for any covered state, the state I'm physically in, any state where I'm enrolling, where a student is physically or located at the time of initial enrollment, who's enrolling on my distance ed programs, or any state where one of those types of students has attested they intend to work, right? For any covered state, an institution must determine that each Title IV eligible program it offers satisfies, quote, the applicable educational requirements for professional licensure certification requirements in the state so that a student who enrolls in the program and seeks employment in that state after completing the program qualifies to take any licensure or certification exam that is needed for the student to practice or find employment in an occupation that the program prepares students to enter. So the shorthand here is for any covered state. So like using my example in Michigan, if I enroll that student in Michigan in a program that is a professional licensure or certification program as contemplated here, in a distance education program, then that program needs to satisfy any applicable requirements in Michigan, right? And that's the idea. And if it does not, what the department is saying is, I can't enroll that student. I can't offer that program into Michigan. Similarly, for any covered state, an institution must determine that each Title IV eligible program it offers is programmatically accredited if the state or federal agency requires such accreditation, including as a condition for employment in the occupation for which the program prepares the student, or is programmatically pre-accredited when programmatic pre-accreditation is sufficient according to the state or federal agency. So again, I'm enrolling a distance education student that is physically located in Michigan at the time of initial enrollment. And Michigan says, for this kind of program, to offer this kind of program, it has to have this kind of programmatic accreditation, right? Then I can't enroll that student if my program doesn't have that kind of programmatic accreditation. Or, and this is probably the situation you may see more commonly. Let's say in order for that student to get that professional licensure or certification in that state, then the state requires the program they graduated from have some type of programmatic accreditation. And that's what the department's getting here when they say including as condition for employment in the occupation. Again, it becomes a problem. I can't enroll that student if they won't be able to obtain that licensure or certification or enter the occupation in their state because my program doesn't have that required programmatic accreditation. Finally, for any covered state, an institution must determine that each Title IV eligible program it offers complies with all state laws related to closure, including record retention, teach-out plans or agreements, and tuition recovery funds or surety bonds. And we're going to talk about a little later what that means if you're in the context of a reciprocity agreement, state authorization reciprocity agreement. Okay. The department makes very clear, in case there's any question here, that the point of this new rule, and they say it here, they say 668.14, that's the stuff we just went through, the new PPA stuff, is intended, and Roman numeral 1 and 2 refer to programmatic accreditation and the professional licensure language I just read for you. They say, look, the purpose of this stuff is to require all programs that prepare students for occupations requiring programmatic accreditation or state licensure to meet those requirements. And the department says if programmatic or licensure requirements exist, quote, an institution must follow them with respect to the students attending from those states. That also means that if an institution cannot determine that its program meets the education requirements for licensure certification, then it cannot offer the program to future students in that state. So remember, I mentioned earlier, you can have that list. You can still say, look, there's 30 states for which you've not made a determination. That's fine. You just can't enroll students from those 30 states, right? Okay, so now enough from me. Let's get into the details. Katie, the first question is for you. Do I have to comply? I'm at an institution. I'm asking this question. Do I have to comply with these new PPA requirements that we just went through for my non-Title IV programs? I've got a boot camp. These are non-Title IV programs that I offer online. Do I have to comply with these new PPA requirements?
Hi, Aaron. Hi, everyone. Happy to join you today. And I see that this question actually has already popped up in our Q&A box a couple times. So happy to kick it off with this one today. The short answer is no. The requirements only cover Title IV programs. So for any programs that you currently offer that are not Title IV programs, you do not need to comply with the new requirements. Also, institutions may, of course, make a determination on their own that certain programs cannot comply, or that maybe it's not worth the cost of coming into compliance. So in that case, then they may change some programs from Title IV programs to non-Title IV programs, which would mean they would also not be covered by these requirements. In fact, some of you probably noted in the department's commentary from the final rules that they specifically say that if institutions don't want to take the necessary steps to comply with these requirements, they can choose to make those programs not eligible for financial aid. Maybe you have an online professional licensure program where very few students use federal financial aid. In that case, it may not be worth having to make those determinations and disclosures to every student in that program. And that scenario actually leads us nicely into our next question, Aaron.
And that is, do I have to comply with the new PPA requirements for students in my Title IV programs if they're not receiving any form of Title IV?
So yes, in this case you do. The requirements cover Title IV programs and do not make any distinction based on whether the students in the program are receiving Title IV funds. So again, in my example from just a minute ago, even if just 10% of the students in a program are receiving Title IV funds, the institution will be obligated to meet the requirements for the entire program, including for those students who may not be receiving aid. So definitely something to think about.
And I'll just offer, if you are thinking about taking a program from Title IV to not Title IV, just keep in mind there's sort of a process you need to follow for winding down a Title IV program. Obviously, you don't want to just decide you're not going to do Title IV on Thursday if you've got a bunch of current Title IV students. So there's a little bit of thought that has to go into that. But it is quite possible to do. Our next question, Russ, so we had our warm-ups here, getting a little more into the details. The law requires that I determine a student's location at the time of the student's initial enrollment. And that's part of that location concept that was inserted by your rulemaking crew, or at least by the department that you were there to negotiate, to be fair. Does that just mean that I have to make the determination at that point in time, meaning I'm deciding where they're located at that point in time, or does that mean I actually have to use the student's location on the day they enroll? Help us understand.
Well, yeah, thank you for that question. And in the 2019 rulemaking, I was the location hawk and things. And so I was really involved in this. And just a quick background on location. That location has commonly been used to mean the place where the student will primarily be located when engaging in instruction, where they will be. And that comes from the state legal requirements that the state only has jurisdiction over institutions that are educating students within their state or institutions that are legally domiciled in the state. So it might be an out-of-state institution, but they're educating people in the state. The state still has legal jurisdiction over that institution. So the institution is required to make a determination of the student's location, and you're given considerable flexibility in creating a policy for determining that location. But what we've heard, both from speakers and from subsequent writings, is that it needs to be something that you can defend as making sense, that you have a good way to make location and that you have a process for that, and that you need to apply it consistently when you're determining location. Now, not in my rulemaking, but in the next one that created the rules that we're talking about, let's talk about the craziness and of the notion of at the time of students' initial enrollment. And this is a phrase that really could have used a lot of sharpening. And it is a fuzzy concept. Cheryl and I were involved in working with some negotiators about that, and we were trying to get that sharpened, but we apologize to you that we did not get that done, so we get to talk about it today. And what's important here on this slide is that we really believe that enrollment is meant to be when the student begins instruction. So not when the student is admitted, not when the student is registered, or when the student signs an enrollment agreement, any of those things. It's that the intent of this, again, is when they begin the instruction. And the whole idea ties back to where I started, because there's a need to determine where the student will primarily be engaged in instruction. What is that location? Because that's the state that has the jurisdiction over what happens between the student and the institution. And the federal rule is meant to ensure that that jurisdiction has been established and recognized by both the state and the institution. So that's what I have on that one.
Well, Russ, if only they had just said, where's the student going to be when they take this program? That would have been, or start taking the program instead of the initial time of enrollment.
Yeah, they actually put it in a spot where it made sense and then started putting it everywhere else where it didn't make sense.
Well, some lawyer probably wrote it. All right. So Cheryl, a question for you then. Staying on this topic, the law requires that my policy for determining a student's location be applied consistently to all students. Okay, but can the policy apply differently, like to online students or on ground students or hybrid students?
I would say that the answer to that is yes, when you consider that the department was providing for variability for the institutions to make determinations of location. So when the preamble was released in 2019, and when the department was out giving presentations about the new regulations, they were talking about how they expected that the institutions would have various processes and they would have to be addressing the academic community at their institution. So they expected one institution not to look like the next institution in terms of how they are sharing what their policy is. Now, they do in the regulation itself indicate, as you already shared, that they are to document how they make this determination and apply it consistently at the institution. Oh, and provide it to the secretary upon request. So they are looking towards the institution, providing a structure that is a policy that can be shared and applied consistently. So I would say that, absent any other indication from the department, which we have not heard, that it can be variable to address different groups.
Yeah. And I, just also, we were talking the other day and we included this quote at the bottom, right, which is from the 2019 Federal Register. So, different administration, but they sort of signaled this in writing there, even this talking about making different determinations for different groups of students. So it seems like there's a decent amount, absent the Q&A or some further discussion from the department, that this would definitely be the case. And also it seems just as a practical matter, it would likely need to be the case, right? I mean, because you could have students who have totally different enrollment cycles or approaches to enrollment. It probably makes sense to have a different way of thinking about totally on-ground students versus online students. So it seems like there's a lot of support for the answer here being yes.
Yeah, so I just wanted to add one more thing, though. Something that we've been talking to our institutions about is going back and reviewing. So this regulation has been effective since July 1, 2020. And so institutions have already developed their policy. But in light of what's happening and the changes that are coming for July 1, it seems prudent for institutions to review the policy they have. And if you have not created one, to consider what the elements are and how that best serves your institution.
Unquestionably. Okay, on the questionably side, Katie, another one for you. How should and Cheryl was sort of getting at this, right? We talk about documentation, and one of the options I mentioned earlier. I mean, you've got the student's location at the time of initial enrollment, and then there's this idea that you might have an attestation as well from the student. So I gave that Michigan example. I said students in Michigan, but they said, yeah, but I want to work in New York. Mm-hmm. How should I go about obtaining and documenting student location and any attestation regarding future employment plans?
Yeah, so this is something that I have happily been helping clients figure out. And we certainly recommend that institutions do develop a specific location determination policy. And that policy would define what constitutes enrollment as well as time of initial enrollment. It would also specify how location will be determined at that point in time, any distinctions among student groups, which Aaron just referenced. And then, I would say processes need to be developed for obtaining this information from prospective students, along with any attestation regarding future employment plans. And then also part of that plan should be maintaining documentation of both. So, we've been advising clients to create the policy, document the policy, train all relevant staff and even faculty on the policy, document that training, and then maintain clear records of this determination that they're getting from the student, and or any attestation from the students as well. That would also include documenting that the student received a copy of the documentation, not just that the school has a copy of that documentation. Another key point in both determining the location and any student attestations about where they hope to work after they complete the program is that institutions should include in that initial determination an affirmative obligation on the part of the student to provide notice to the institution if that location changes, or if their intentions about where they want to live upon completion change. I also recommend that they include specific instructions on how that notice should be provided by the students. So all of that together really should create a solid paper trail for the school to point to if need be down the road.
I've been keeping an eye on the Q&A, and someone asked a question, which is, we now, understandably, it's like, are we now responsible not only for determining a location, but also gathering attestations? And I'll just highlight for folks that the department included the attestation option really following public comment, because the point commenters made was, hey, if we've got if we have a student that's in Michigan, but we know that the student is not intending to work in Michigan, but is intending to work elsewhere, and we satisfy the requirements in that other state, in my example, New York, can we enroll them, even if they're going to be sitting in Michigan while they take the program? And the department said, okay, yeah, we'll allow that. So really the attestation concept was intended as a convenience for institutions, not as some sort of additional burden or penalty. You could, as part of your process, ask schools, or schools could ask students initially when you're dealing with prospective students, what state are you going to be physically located in? You don't have to ask them for an attestation, but if they come back and say, I'm going to be in Michigan, and you don't satisfy mission requirements, then you could follow up and say, do you intend to work in Michigan and seek employment in Michigan after graduation, or do you intend to go somewhere else? And if they said, actually, no, I'm going to go to New York, you'd say, would you complete an attestation to that effect, in which case we can enroll you? So, you don't have to request attestations. You don't have to make that a part of your process. But if you don't, you won't have that option of potentially enrolling students when maybe you could. So I just want to highlight that that's really intended, I think, primarily as a convenience for institutions, not as a penalty.
Aaron, could I add a little bit of color to that?
Please.
Do you mind?
No, please.
So what part of this is, we were trying to reach the department through our public comments and testimony, et cetera, to indicate that there could be military students or military affiliated students, government affiliated employees and students that are only in a place for a short period of time. And so we were hoping that the department would recognize that and plan for an option so that a student isn't penalized because they're finding themselves temporarily located in one spot, but they only are going to be there for a year and moving on then to another area, never intending to stay in that location. So I think this was the department's willingness to see some options. And again, I think you said the word option before, and I want to underscore option, never a requirement, but an option for the institution to be able to serve that student in those circumstances.
Yep. And look, if you go read the regulatory language, much like Russ's point around time of initial enrollment, some of this language is maybe not as elegant as it could be. And it can be a little confusing, which is why the context and the comments and the department, they include in the Federal Register to the final commentary, the final rule, they say, like, this is why we put this in here. So that's how we know and get a little more sense as to what the whole point of it is. Because I only say that to say, if you go back and read the regulatory text, it may not always be clear, and we certainly acknowledge that. Cheryl, this question is actually for you. So how do I determine the location of a student? And this is a big part of it, right? We're going to get in a minute to how do you decide if it's a professional licensure program, which I know is a major question schools are wrestling with. But even this location idea, I did see somebody, by the way, in the Q&A ask, where in the regs are you obligated to determine location? Again, that's at 34 CFR 600.9, and it's also at 34 CFR 668 43 in both of those spots, and those sites are earlier in the deck. But understanding that obligation is there, Cheryl, how do I determine the location of a student who intends to take some classes on ground and others online? So this is the hybrid issue. And what if the student will be located in a different state when they're on ground than when they're online? So, and you and I have talked about this. I live in Virginia. I'm enrolled at George Washington University. I'm going to be an on-ground student for the most part, but I have a little optionality, and I decide to take, one class for 1 or 2 semesters online, but I'm going to be at home in Virginia, not in the district when I take that class. And maybe the school has the professional licensure stuff sewn up in DC, but not across the river in Virginia. How does the school decide the location?
That's a really difficult question, and it is one. So just to start with, I do want to point to the fact that I really appreciate that when these rules were released as final in the fall, that they offered a contact person for the different issues. And the person that was the contact person for certification procedures has been very responsive. And I really appreciate her responses, not only to me, but also to many of my SAN member colleagues and others who have asked questions to try to get some implementation understanding in this kind of situation. Because, you know, what we see here is that that students are participating in courses in a term that could be some in person and some online. I mean, it reminds me of the old days, and this just shows how old I am. I remember taking a course at night once a term so that I could free up my day. Well, we have students who are doing that with an online section of a course that has online and in-person sections, but they choose the online section. So we've got that situation here. And so the description that you just shared, Aaron, is one that I shared with the department's contact. I said, this is the tri-state area or the multi-state area question. So you have a student who is participating in this program that leads to a license, and it is a program where they are intended to be a resident student, but they take a single course. Could be an elective, or it could be a gen ed, and the department is saying that from their perspective, that causes the institution to have to consider that student in that triggering part of satisfying the state educational requirements where the enrolled student is located at time of initial enrollment. So they're saying that single course, even though they are participating in the program in person, that single course is triggering that other aspect. And so it is curious. And the reason I say it's curious too, because in terms of creating your location policy that we just talked about, the department was very open with how you determine location in terms of, you know, how it fits your students. But then when we come to this circumstance where we have a state line issue, and the department is being very specific that they think that where the online portion is the priority, and indicates that that must cause the institution to address satisfying state educational requirements, even though other parts of the program are being in a residence face-to-face situation in the other location. So at this point, that's what the department's thinking is. So if you have one course at time of initial enrollment, then you are to be looking at satisfying the state educational requirements where that student is located for the single online course.
Wow. So let's just walk through this, Cheryl. So if I've got, again, we've got this example where we've got a student and she lives in Virginia. She's enrolled at GW. She's coming across the bridge into the district to GW to take on-ground courses. Now, let's say, first of all, let's say she's not going to do anything online. Her intent is to take all of her programming on ground, and she registers for her first term. All her programs are going to be on ground. I would think under most institutional policies, she's located in the district, right? Does that sound reasonable?
Yes.
Okay. So she's an on-ground student, good old-fashioned on-ground student. She's taking all her classes are on ground, and she's located. She's going to be as Russ mentioned earlier, she's going to be doing her instruction in the first term on ground in the district. Okay. Let's say she's an online, 100% online student, and she's going to be sitting in Virginia across the river for the entire time. Most policies, she's probably going to be deemed located in Virginia, right? I mean, it's 100% online.
Makes sense. Yes.
Okay. But she says, I want to be an on-ground student, but in my first semester, I've got the option, and I'm going to take one course during my first fall term online. So I'm going to be sitting at home in Virginia, taking that course online during my first term. And what I understand from the department, and I just want to be clear, what you're saying is then the institution would have to determine that at the time of initial enrollment, she was located in Virginia.
That is what we're getting in unofficial guidance. So again, as you pointed out, we're looking forward to a Q&A, and we wonder if the department's chatting on this themselves as they create what might be official guidance to be able to explain this a little bit more in more detail.
Well, and it certainly seems like, and we've had this conversation internally, so I'm leading the witness, but it certainly seems like if I'm an institution, many institutions, I would just say, okay, well, first semester students aren't allowed to take any online classes, and then they can take online classes after that. But if the location determination is made at the time of initial enrollment, and the department says what we really mean is, are they taking any online courses during the first term? And if the answer is no, you can just treat them like an on-ground student. As an institution, it seems like it would simplify life just to say, okay, well, online options aren't available in the first term. I'm not asking you to indicate whether that's a good or bad idea, but consistent with what we're hearing out of the department, it seems like that might be a path that some schools would take. Fair?
That is very consistent. I will tell you, 2 years ago, when we were talking to a couple of negotiators, Russ and I, discussed issues about, how long is the institution responsible? Because if, let's say, they do make they do follow the other aspect of the location regulation that indicates when they have received a notification from the student of a change, that would also then bar a student from being able to complete programs. And the negotiator at the time was very concerned. No, we don't want to put barriers to students who are already in programs because they're moving. So those notifications will become really important to keep those students up to speed. But they wanted to have a single point in time to begin the structure, that's where they thought would be the most difficult for a student that would be starting into a program that might be something that they cannot be able to seek employment once they complete the program. Right. So I think they think the risk is there at the beginning. And so I think that's why the focus is on that point.
That first term, because obviously an alternative would have been to just ask students where are you going to be located for the majority of your program, and just take whatever they suggest they believe is going to be the case. But the department seems really focused on this first term, this time of initial enrollment. All right. So Russ, the other big question. So one of the big questions here that we hear a ton from schools, and we're seeing in the Q&A right now, is of course around determining location. The other is, and I hear this all the time, I just had a professional colleague in Missouri reach out this morning about this. How do we decide which of our programs are professional licensure certification programs?
Well, that's a good question, and I'm noting that I'm getting all the definition things. That's probably appropriate because I always love getting definitions in there, and unfortunately, this is another one that's not perfectly clear because there's not a strict Department of Education definition, and maybe we need to wonder whether that's a good or bad thing at times, whether because sometimes the definitions get too narrow on some things as well. Instead of unclear, one of the things I might use is the phrase that I love is it depends. What is a professional licensure program? Depends on the profession, and it depends on the state. So as a state and then the profession in there, that they decide what it is. And I'll keep coming back to that in these comments and in others later on as well. And for example, did you know that Louisiana is the only state that licenses florists and flower dealers? I can give you the link for that to get it. And presumably a flower arrangement fell on someone someday or something. I don't know what the heck happened there, but they're the only ones that do that. So, there are times where you think, why would they regulate that? But somebody does. We're also going to discuss some situations later where it could depend on the person, but let's save that for later. As you'll see, the Department of Education regulations are not consistent as there are differences in the terms used for disclosure requirements for professional programs and the terms used in the program participation agreement that goes into effect on July 1st. And both conflicting terms will be enforced on July 1st. So let's go to the next slide to see where we're going here. And we've done that, I see. Okay, so let's go back one.
Oh, sorry, got it.
Yeah, I wasn't quite there yet. Let's see. So let's go to as you may recall, there has been a functional definition of sorts as shown above for this phrase, for purposes of disclosure for a professional licensure program. And that language requires institutions to notify students whether a program meets the educational requirements for all licensure certification programs in the state. So the 2019 rulemaking that produced the language on the left on this slide, I was involved with that, and we made sure that we had educational requirements to narrow that down so that it's just where you're meeting the educational requirements, because there could be a lot of other requirements in professional licensure. And also we really tried to narrow it to a program that is designed or advertised, and we'll keep coming back to those words, to meet those requirements. It's something where you've taken a positive step to do that. Now, the box on the right is from the program participation agreement language that goes into effect this July. They took a little bit different tact on that, unfortunately, and they focused more on the profession in the state. And the focus is on the licensure exam, and which might be only one of the educational requirements. And so we're not sure why they went off of the language they already had, but there you go. I think part of it is that they introduced it very late and didn't do adequate research to see what else they had out there. And sometimes these things go fast and you don't get the best language. And I think we have that here. So Erin shared with me a response about this issue that came from, and Cheryl had mentioned Vanessa Gomez from the department has been great in answering questions. And one of the things that she said was that we were looking at specific state requirements, and if such requirements do not exist, then licensure and disclosure requirements would not apply to those programs. Finally, I want to remind you that who gets to decide what is a licensed profession, and it's the state, that they have the final word. So you're going to need to, continually look to see what are the requirements in the state, and what happens with the what are the requirements in the state, and see whether you meet those. There's a lot of times where people get into, we're going to talk a bit more later about national licensures, or they have assumptions of what it is in the state. You actually have to do the research to get that. Okay, and I see that you're moving me along to the next one, and so to another question that you see here that Vanessa says is doubling down on this design or advertise thing, which is good. So it's going back to where we really wanted to get back to what it is. She says that if you advertise or design and it meets licensure, and the state has licensure requirements, you must also follow the federal regulations. And if the state does not require licensure, that you don't have to follow it. And so that kind of makes sense. If they're not regulating you, federal government's making sure that you're following the state laws around licensure, so you don't have to do any of this. And I keep coming back as the non-lawyer person on this. I'll repeat again, this two-step process of know what the state licensure laws and regulations are for the profession in question in the state. That's number one. Number two is follow those laws and regulations. And so, Cheryl, you've been following this designed and advertised issue closely. Could you, what do you have to add about that?
Sorry.
Would help if I went off mute.
Yep.
All I would say is that I think that the regulation in 668.43 really could draw out like a checklist. It was really helpful to determine what applicable programs, that were required to do the notification structure. And so when you look at that, and I really compliment the 2019 rulemaking for the design of that regulation, and I've been able to share that with institutions because they wondered if their program was one that was applicable. And I said, well, take your program and go through this list to see if it is one that needs to have these notifications. And so I'm really happy to see that we can point back, or it appears we can point back to a really nicely structured set of elements that allows us to determine what the programs are that are applicable to these regulations.
So, you've got this idea then, as Russ pointed out and Cheryl pointed out, that there's no specific definition of professional licensure or certification program. And we've got kind of two different concepts floating around in the regulations. The department, as Russ also noted, does seem to still be, notwithstanding the fact that the language in the PPA new language in the PPA requirements and the language in the disclosure section of the regs doesn't harmonize perfectly. The department and what we're hearing and through that unofficial guidance seems to still be hanging on this notion of, designed and advertised. And it seems like they're going to stick to that. The question, though, that we keep getting from schools, and I'm seeing in the Q&A and even this morning, is, okay, we don't have a definition. We have a couple of concepts, but functionally, practically speaking, how do I sit down with the folks in my institution and decide which programs are our professional licensure certification programs? At the outset, and I'm going to answer this question. I've put my own name here on this one. At the outset, just a reminder that it's your Title IV programs. So non-Title IV you can take off the list. And we understand that, there are different ways schools may want to think about this. I've attempted to come up with a little bit of a rubric here. I won't Cheryl and Russ don't have to sign off on this one. But we're trying to think about a way that, if you're sitting down around the table at schools, you could approach it. And it also, I've highlighted a few words here in red that I want to emphasize because I'm seeing questions in the Q&A that I think some of this, if you'll really look at this definition or these concepts, will help answer these questions. So the question I would ask is, if I've got a program in front of me, and I'm going to say, what if you've got, engineering and accounting or some of those programs that are tough to wrestle with, right? Because there are some states, or like Russ said, florists, but there are some states, engineering and accounting, a lot of schools offer those programs. And some states may include some requirements and others don't. It's not always clear if they're really intended as professional licensure certification programs by the school, much less whether they satisfy various requirements. So what I would say is start by saying, okay, we've got this engineering program. Let's say it's an undergraduate engineering program. And then I would ask, okay, for any state that we're aware of, for any state, did we design this program or are we advertising this program to meet the educational requirements in that state that would be needed for students located in that state to obtain a specific professional license or certification that is required to practice in that state in the occupation the program prepares students to enter? So there's a lot of stuff to break down here, right? First of all, did you actually, for any state, any of the 50, did you actually design the program to satisfy these requirements? Or are you advertising? If the answer is no, it would not be a professional licensure or certification program because you've not designed it for that purpose and it's not being advertised for that purpose. Let's say you designed it and you're advertising it for some purpose, but in that state that you're concerned about, there is no specific professional license or certification requirement. Then again, this wouldn't be satisfied. There may be some other kind of requirement out there, but if it's not a specific professional license or certification requirement, you could say, again, we don't think this is true in any state in which we're offering this program, and we certainly did not design it, and it's not being advertised as satisfying some specific professional licensure or certification requirement that is required to practice in that state. It's another important word. So there are certainly optional certifications out there that may be beneficial in seeking employment in various states, but under the state law, is it required that a person have that specific professional license or certification in order to enter the occupation in that state? And then finally, I think it's worth asking, what is the occupation that we're preparing people to enter? And the example I give is, you may have a program. There are programs, PhD programs in law, for example. Those are not JD programs. Those programs are not designed to prepare people to sit for the bar and become practicing attorneys. They're PhD programs. They're designed for people who want to go on to universities, become academics, and teach the philosophy of law. So you might, as a university, legitimately take the position that this PhD program in law is not designed to prepare people to enter the occupation of being an attorney. Right? This having been said, if you answer this no, if you don't think for any state we have designed this program or we're advertising this program, again, to satisfy educational requirements so that students in that state can obtain a specific professional license or certification that is required to practice in the state and the occupation that we're preparing students to enter, if you think the answer to that is no, I would still suggest that you should very carefully consider whether you should be in the program description elsewhere on your website, indicating and including a specific disclaimer in the program materials because there could be confusion among consumers. Not everyone entering a PhD in law program may fully get what it's about. Hopefully they do. It's a PhD program, but certainly in certain certification or diploma programs or undergraduate programs, they might not always understand the distinction between an engineering or accounting program that's, you know, designed to prepare them to be a practicing an engineer CPA or designed for some other purpose. So just to be safe, talk to your attorneys, but my advice would be really careful. If you think that students might not get this or intuit that your program isn't designed for that purpose, you probably want to go out of your way to make clear that that's the case. Let's say the answer is yes. Maybe it's just in the state in which you're physically located. Let's say I'm a school in Missouri and I'm enrolling students here in Missouri in my engineering program. It is a licensed program here in Missouri. I don't know if that's true. I'm saying for the hypothetical. And there's some certification, right? And we designed the program specifically so that they can get that certification and practice. Then in that case, it is a professional licensure and certification program. For at least one state, we satisfy this requirement. I believe that that triggers then the disclosure requirements at 668.43, because that's the way the law reads. It says if you got a program that's one of these kinds of programs, then you got to make the list. And you got to say, where does it satisfy the requirements? Where does it not satisfy the requirements? And again, optionally, you could still say, and these are the states for which we've made no determination. So let's say I'm a small school in Missouri. I'm only on ground. And maybe I do offer this program online, but only to residents of Missouri, right? So it's a professional licensure certification program because I've designed it that way and to be that way. But I'm just going to put on my website, right, that we've not made a determination for the other 49 states, right? And then I'm not going to enroll anyone from those 49 states. So I've satisfied the disclosure requirement and I'm separately satisfying the PPA requirements, right? So I think what you want to do is first decide, are you in or are you out? Is this for any state a professional licensure certification program, we think? Then you have to say, okay, now I've got to do the list and I'm going to have to make the disclosures as required in 668.43. And then separately, we have to decide, do we satisfy the standards in all the states where we're enrolling students if it's a distance education program? If we don't satisfy the standards in those states where they're located based on the location determination we made, then we can't enroll them. Or alternatively, we can reach out to them and ask them for an attestation in the event that maybe they want to come and seek employment right here in Missouri, where we do happen to satisfy the state requirements. And if you can get that attestation in place, you might still be able to enroll them. I think hopefully this is a little bit of a workflow. You don't have to follow this one, but I know a lot of schools are struggling with this concept and we wanted to give them some kind of construct. All right, here's our second secret word. It is home run. So it's B as in boy, home run. Go ahead and click that out. I know we still have several questions we want to get through for you guys, and we really wanted to get to the neg reg if we could. So go ahead if you're an attorney and you are looking for that CLE credit, trying to give you about 30 seconds here to click B as in boy, the second option, home run, consistent with our opening week of baseball theme. The first, what was it? It was pitch, and now we've got home run as B, so we've moved to the batter's box. And I don't know, maybe we'll see if there's something about an outfielder in the third one. I don't know, I didn't pick these out, so it's always a surprise. So fill those in if you can, giving you just another second to do so. Looks like we're getting a pretty good feedback. All right, let's get on to the next question. I hope everybody got a chance to click B, home run. All right, Cheryl, this one's back to you. How do I determine? We talked about like one of the reasons you might conclude that you don't have a professional licensure program is because your program is not designed to prepare people for that occupation that may require a license, right? That's not you. You're not concerned with that occupation. How do you decide what occupations your program is preparing students to enter?
That's a really good question. And what's interesting about this is that when you consider the financial aid office, and we're always urging collaboration between institution offices, because your financial aid office has likely been managing the types of enrollments, or excuse me, the type of occupations, because it's required in terms of consumer information. And so you may already be doing that at your institution. There's already that obligation to do so. But I urge interaction amongst offices to see how that's being done so that there's some understanding and also clarification because the institution does have, they're in a position to determine, what programs they're preparing students for certain occupations. And you can see a hyperlink there for a crosswalk by inserting the zip code to see a variation of occupations. But I think what's really important to also point out, and I'm glad that this is something that Aaron was starting to allude to, I think, is when you're advertising as meeting requirements, sometimes your marketing department can get ahead of you. And so you want to make sure that you are in sync about what is being held out as occupations for which your programs are leading to, so that you aren't marching towards some sort of misrepresentation issue. So you want to be aware of that. So I would say a collaboration of determination of what occupations your programs will lead to, and that can be informed by this zip code crosswalk opportunity as well.
Yep. And again, I think you can make this determination, you have the discretion, but if you're going to take the view that your, accounting program does not prepare people to become accountants, or something like that, I would just say if it seems counterintuitive, you probably want to go out of your way to make that clear in your materials, right? Otherwise, you may end up with some consumer confusion, and that can cause problems for you.
So transparency is very key in this situation.
Absolutely. Russ, back to you, sir. If my program does not satisfy the requirements of a state where a prospective student is located, but the student tells me she doesn't want to enter any of the occupations my program prepares students to enter, or that she doesn't want to even work after graduation, can I enroll her anyway?
Well, that's a really good question. As you can see, where someone could argue that they're both meeting the student need and not violating a state law. However, as the answer says, there's no such provision either in the existing professional licensure disclosures or in the coming July 1st program participation agreement regulations that allow for any sort of exception for a student who declares that she will not seek employment in that application. And so I think there's a couple worries here that maybe the department has, or maybe they didn't consider it. But I think they worry that the student may in the future want to pursue that profession. It's quite an investment, right? And I think the other is that there may be institutions that try to game the system or defraud students by getting them to assign their rights away on this issue.
Absolutely. Thank you, sir. So a related question for you, Cheryl. If a student attests that she's going to seek employment, but again, in a state other than the one in which she's located at the time of initial enrollment, then do you have to satisfy the new PPA requirements for both states?
So that's a really interesting question, because when you look at the regulatory text, as we see here in the answer, it's not completely clear. We know the department's intent because we have the preamble, and actually related back to what Russ was just saying, the preamble was addressing that as well, that they assumed the student, they don't take the idea that a student would want to pursue a program and not want to be licensed. And so here again, we're seeing preamble offers us the intent of the department in the regulation, but their intent was to offer an option for an institution that is offering a program to a student and they do not meet the state educational requirements in that state, that there is an option that would provide for an alternative if it meets the state educational requirements in another state. What I would indicate here is that it's very important that the institution manage this carefully. It's something that they're going to want to document well. Key things about this is that it's more than just a document, that you must have a process that shows that the student was able to make an informed decision to provide the attestation. And why do I bring that up? I bring that up because we get the question a lot from our institutions asking us to share an example of the attestation document. And so my response typically to that is to take a step backwards from that and talk about how are you going to develop a process that provides transparency of which states the institution does satisfy educational requirements and clarity about how the student comes to their decision. So it is really a tricky area. It's a good option, but it's something that the institution has to be very careful, document well, and have good communication with the student in making that attestation.
Absolutely. Russ, another question for you. What if my program prepares students to enter an occupation for which there's a national certification or license exam, but it's optional?
Excellent. Okay, yeah, Cheryl made me take this question because I get riled up over how some people try to find loopholes around this one, right, Cheryl? But Cheryl said she'd keep me under control here. So, but in considering these exams, the key is to think about the state regulations again, and what each state and what each profession in that state requires. And so you may hear the term national exam. You can't see my air quotes there, or national certifications. That there's no national authority that overrides each state. While it may be common practice in a profession for a common exam to be used all across the country, it is still up to the state to decide whether it's going to accept that exam or not. And there are some cases where something that's labeled a national exam might not be accepted in a state, or the other is that there could be additional requirements. But just having national on the name of the exam does not make it so, does not make it a requirement in every state. So you have to do the work to understand the requirements for each state. And just because it is an optional exam for some states, you can't assume that it's optional everywhere. And so, and there's more on this. Let's go on to the next slide and talk about this one. Let's get to that question too.
Absolutely. What if my program prepares students to enter an occupation for which there's an optional national certification or license exam, but the specific state in which the student is located does require the national certification before a person can practice the profession in the state?
There's so many options on all these things, right? So this question is about an optional national exam, but the state in which the student is located requires the national certification as a precondition for practicing. Again, I go back to the state gets to make the rules about the profession. You have to prepare the student to succeed in the national exam, which means you need to know that what generally is in the exam, and that they work with you, and be able to point to the curriculum that covers those topics if you're ever asked about it, like in a federal financial aid review or something like that. How are you matching those up? If your program is not aligned with that optional exam, there will be a problem in that you won't be meeting the state's needs, and then we'll run into the federal problems as well because you're not meeting the state requirements. Finally, I really like the red coloring on the emphasize. Thank you, Aaron, for that. Sometimes programs assume that just because they meet the requirements for what is called a national exam, that is all they have to do. It's a national exam. Everybody does this. Well, but for some professions, even though every state uses that exam and it's what's required for that profession, there can be additional requirements on top of that exam. And so you need to, once again, you need to examine state by state because there will be some additions for whatever reasons in particular states. Cheryl, what would you add to that? Let's see.
I just think you're spot on. We have tried to help our institutions understand that the state is the one who makes the determination of the elements to lead to a license, and that the national exam may just be one element amongst the various state requirements in order to obtain a license in that state. And so, yeah, I'm amused. Whenever Russ and I get to present a lot, I'm very fortunate in that, but I noticed that whenever we create a slide deck and we get to this, Russ puts his name on it, on that section. So definitely wanted Russ to provide it this time. So, but Russ covered it really well. Thank you.
So I'm going to actually, I think it was Katie, I'm going to skip this next question and I'm going to push to our question on multi-state agreements, which Cheryl was free because I think we'd already answered the other one. Cheryl, if my institution participates in a multi-state licensure compact or agreement relating to my program, will that satisfy the new PPA requirements for professional licensure? So by way of example, if I enroll that student in Michigan and we're not able to meet the Michigan requirements, but we do meet requirements in another state where the student says they want to be, wait, let me make sure I get this right. So let's say the student's in Michigan, but our program is designed so that they could get licensed in our home state where we're located and then waive into Michigan through reciprocity and practice the profession that way. think that's the right way to say it. So if there's that sort of compact relationship in place, does that get the job done?
This is a very good question. And honestly, I do appreciate that the department considered this in terms of information in the preamble, because compacts and multi-state agreements support the Biden administration's executive order back in July of 21 to minimize barriers to a license. And so, the Council of State Governments is doing a really great job working with professions in the development of professional compacts. And there are a variety of professional compacts. So in the preamble, and I want to underscore this was in the preamble, not in the regulatory language. The department addressed that satisfaction through these compacts and agreements would satisfy the requirement. But I just, again, want to be clear that it is not in regulation like the attestation part was. So I have like a big yellow caution flag here in using this. And the language that they use in part of that quote there that I really land on is because these are all forms of licensure. We do not think a regulatory change to capture this concept is necessary. And that is from questions that were asked about, well, what about compacts? There's already a pathway, because the whole idea of this was the department wanted there to be dots connected from education to be able to be employed. And so these multi-state agreements and compacts can provide that. A couple of caution items to consider, though, is that not all professions have a compact or an agreement. And then, even if there is one for that profession, not all states belong to the compacts or the agreement. So, you need to consider that, and also consider it needs to be licensed to license. And so I think teaching's one that you can say pretty easily, there's like a K-5 license. And so if the institution has received, is able to confer a particular license on that particular, education to obtain a license where the institution is located, but where the student is located is also a member to the agreement, that they are able to take their license earned in the state where their institution was located, and then be able to use it and be able to be employed in the state where they're located. So it's very important that there be steps to employment. The department in the preamble also indicated that if it will bring the student a provisional license, that would be sufficient as long as they can be employed while they are completing whatever extra requirements there are in the state. So it is a pathway. It's just one that really needs to be reviewed carefully by the institution. It's not provided in regulation. It's only in guidance of the preamble. And I would say documentation and proceeding cautiously is the way to be able to use that effectively.
Agree completely. And look, we do anticipate guidance to come out from the department, and this is one of those places where you'll want to look specifically at the Q&A and see if they've addressed this or provided some sort of additional comfort that you can point to if you're gonna go this route. By the way, just a couple of quick notes. One is we do have the ability to go a little past 3:30, so we're going to try to keep going to till 3:40 or so to see what we try to get as far in as we can. The other thing is we did update. Somebody mentioned that the links weren't working in the PDF that was originally in the resources. We've put an updated PDF there. You may need to hit F5 to get it to refresh and give you the updated file. Look, if for some reason the PDF links don't work for you and you can't get them to work, just email us and we'll get you a copy. That is not a problem. All right, let's see. Implementation. What if I have a student enrolled, and Katie, this one's for you. What if I have a student enrolled in a program right now and the program does not meet state professional licensure requirements in the state where the student's located? Do I have to stop offering the program to that student come July 1st?
So in the preamble, as noted on the slide here, to the final rule, the department observed, we also recognize that this provision could affect the eligibility of some programs, and their goal is not to have this apply retroactively. So it would cover new program entrants on or after July 1st of 2024. So students who are already enrolled as of July 1st may remain in the program, but as we've previously discussed, the school will need to cease enrollments after July 1st for any states where the program does not meet the licensure requirements. So while it's good that it's not being applied retroactively, I think, in reality, this really could lead to some real confusion for students and prospective students. So something to think through for institutions with programs that are affected by those July 1st requirements.
Yep. And, I'm focused too on this new program entrance language. Sort of takes me to the next slide here, which Russ and Cheryl, I'm throwing this one to you guys collectively. But, we've seen this type of setup in the law and including in this regulation with regard to other aspects of the rule package, where the department actually used the word enrolled. And it said if you had someone who enrolled before July 1st, then it's okay. If they enrolled after July 1st, then they're subject to the new requirement. And here they use this weird word or phrase, new program entrant. So the question is, if I have a student who enrolls, let's say signs an enrollment agreement or sends in their money and registers in May, but they're starting in September, right? Would the student be deemed a new program entrant who began after the effective date? So are they a new program entrant before July 1st or after July 1st?
Yeah, we say that that's unclear because it's not specifically spelled out, and we're waiting for those promised question and answers. So we hope those come out soon. And we mentioned before that enrollment seems to focus more on when the student starts instruction as opposed to being accepted, registered, or entering into an enrollment agreement. And so I go with the student who starts after July 1st, and that's when they start the instruction, that's the new program entrance. Of course, that opinion and $6 will get you a cup of coffee. But Cheryl, what do you got?
Yeah, honestly, I agree with Russ. I think that let's talk about the spirit of the rule. It seems that the department was looking that the student who is beginning their program after July 1 is protected. And so even though they're, actually beginning the activity of the program after July 1 should be protected, and not about this management of administration stuff to try to beat the clock. And so I would say that this is the department was intending to protect these students who begin their coursework on or after July 1.
Yep. By the way, somebody asked, what if they're changing their major? So they enrolled in one thing, and they're already in, sort of in enrollment status in the institution, but they're going to start their professional licensure program after July 1. We don't have that kind of detail either, but I'll just say, again, Cheryl's point is the department would probably take the view that if they're starting the professional licensure program, major, however you want to think about it, after July 1, the department's intent is that they be protected. So I think if you're going to take a different, go ahead, Russ.
Yeah, you better be notifying them on all these things.
Yeah.
Because
if you're going to take a different view, talk with counsel. Just be real thoughtful about it. Russ and Cheryl, another one for you guys, and somebody put this akin to this in the Q&A. What if I'm offering a program? Because we talk mostly about professional licensure. Some of this also would get to the programmatic accreditation piece too, but this one specifically on programmatic accreditation. What if I'm offering a program that is in a pre-accredited status, but the pre-accredited status in and of itself is not sufficient to satisfy state licensure certification requirements in the state where the students are located? So as of right now, my program is pre-accredited. Even, let's just say at my home campus, I'm rolling out a new program right here in my main campus, physical location, and it's pre-accredited. But, for these students, when they graduate to actually become professionally licensed or certified, they have to graduate from an accredited program. How do I go about that? How can I enroll them in the program?
This is a very difficult one. I do want to say that when I was listening into the winter 2022 rulemaking, I believe that the department was listening to that accreditation representative, and I appreciated her thoughts to explain to the committee that programs must graduate students before they can be fully accredited so that they will exist in this pre-accreditation status, and that is considered legitimate in many states. And so wanted that to be, acknowledged within this regulation. But there could be some states that indicate that pre-accredited is not sufficient for licensure in that state. And so as you see the response here on the slide, you're just going to have to watch it and apply as necessary at your institution. So if the issue is your home state, then your choice is to not seek Title IV approval, and then you can offer it more broadly until the program achieves full accreditation, but with no Title IV. And if the issue is in other states, then the institution could refrain from serving students in those states until full accreditation is achieved. So it's a decision that the institution will have to make based on what is required by specific states.
And
I'll just
oh, sorry,
go ahead. Well, and just a quick thing to add that it might be worth a conversation with the licensing agency in that state, because they may have old rules and not have considered pre-accreditation, and they may have ways that they can make accommodations for that. And sometimes that, talking to those agencies, you can learn a lot, and sometimes they'll be very strict, and sometimes they'll say, oh yeah, we've done that before and we've allowed it, and that's how we interpret it, is that you can allow pre-accreditation.
Great point. And as Russ highlighted earlier, at the end of the day, it's the state that decides, what's required for the occupation, not the feds. That being said, I don't, this is an example where, my sense is this would be an unintended outcome and not something that the department was necessarily, intending. And I would really look hard at the Q&A. I think a lot of people are going to be asking this question, and it will likely be addressed, is my guess on this one. Russ and Cheryl, last question before our last secret word for those of you who are holding out. State law closure compliance. So this was that last little piece. And, as we noted, in any of these covered states, the other thing the rule says is that you have to comply with that state's closure and related laws and sort of closure laws and things that relate to closure. So if I participate in SARA, do I really have to comply with state laws relating to closure, including retention and teach-out plans and agreements, tuition recovery funds? I mean, isn't the whole point of SARA that I'm in SARA, I'm authorized at home, so I don't have to comply with those types of things in other states?
Russ, you gonna take first crack?
Okay, I could do that. And here
I can if you want. Either way.
Yeah, I can go ahead. Here, we run into some conflicts here between what the department might have intended in the language, and so we hit that at times. But the way it's written, I would say that for the purposes of the regulations going into effect for the program participation agreement on July 1st, okay, for those, SARA will cover it, and that's what we believe. That is how the language is written. However, the opposite is true for the proposed rules that were negotiated earlier this year. And so we haven't gotten into those yet. And so that creates a lot of confusion where you have these things kind of going one way for what's for July 1st, but for the rules that haven't even been put out for comment yet, it could go a different way. Do you want to say more about that, Cheryl?
Sure. So I can just share a little bit of reasoning behind it. It's because the states agreed that they would follow the policies of the reciprocity agreement for the institutions.
Cheryl, I'm sorry. I'm just going to pause you real quick. I want to give people a chance to click the third word because people are having to leave. So the third word is Jersey. And Cheryl, you could keep going. Please keep going. People could click Jersey while they're listening.
Sure. Because it's so exciting what I'm going to share. So what I'm just saying here is that states agreed that for purposes of the institutions to be approved, that the process is the reciprocity policy, and so they would be with on the outside of the reciprocity agreement. They would be contrary to the agreement if the states that are participating in reciprocity or that are members to the reciprocity agreement would try to enforce these education rules for closure. But what Russ was saying is, spoiler alert, there are regulations that are being discussed that could be effective in the future, that could cause that, even though there's a reciprocity agreement, that closure laws would be something that these states can enforce. So we're waiting and seeing on that. But as far as July 1, 2024, just like Russ said, we believe that the institutions that are participating in reciprocity are covered in terms of following appropriate policies for closure. But one thing that we talked about is that there are general purpose laws. So if there's some sort of surety bond or something that's required for any business or organization, then those general purpose, and I don't know what now, I don't have an example of that, but general purpose laws are applicable. So an institution could be subject to that if there is a general purpose law that would be part of that state's laws. That's the only exception that I would see.
Absolutely.
Contradict me if you will.
No,
Russ,
I won't. Yeah. So again, Cheryl, appreciate that. And I'm just hoping folks get a chance. I know that looks like there were a few, maybe didn't get to the third word. I apologize for that. You can always reach out to us. We'll figure that out for folks who may have had to jump. Hopefully most of you, looks like a lot of people did though, get a chance to click on Jersey. And so here's what I want to do. I want to try to get to some questions, and we're running tight on time. I just want to note real quickly for folks then, just very quickly, we've got this program integrity rulemaking, right? This rulemaking is part of the department's 23-24 neg reg schedule. And the 2024 program integrity rulemaking included state authorization and distance education topics. They met in January, February, and March of this year. They did not reach consensus on these topics, which means the department at this point can go to the sort of back to the drawing board and put together proposed rules. Right now, the department is suggesting that these proposed rules, if it releases them, it'll be in October 2024. So it's still a ways out, right? So these were just draft ideas that the department put up for negotiated rulemaking. These have not become rules yet. Covered a lot of ground. State authorization and distance education were both covered. And what we've done is we've put here bullets that go through some of the big ideas in state authorization and distance education, respectively, that were discussed. And you are welcome to check those out. But I'll tell you what, I'll leave for state authorization. I'll leave that on the screen here, and I'll flip to distance education. But what I'd like to do, Russ, Cheryl, and Katie, is to try to, I mean, we've got 85 questions, so we're not going to get through all of them, but I'd like to try to at least throw out a few of the ones that I've seen. So one of the ones sort of categorically that it keeps coming up is, you know, what if folks change their location during the program? So we verify let's say it's a distance education program, just to keep life simple. They're in Michigan. We satisfy mission requirements, and we've got a process for determining, you know, when they change location, they notify us, yeah, I'm moving to New York, but we don't satisfy New York's requirements. What is the expectation with regard to that student? Do we have to stop educating that student now that they are located and taking the program in New York, which is a state where we don't satisfy the requirements?
Russ, I'm going to jump in if that's okay with you.
Yeah, please do.
So the preamble was very instructive in that way, indicating that you could continue to serve the student. This is where that harmonization of the notifications comes in handy, because you do want to keep them up to date on what the status is, where they're located, but you are permitted to continue to serve them if they are to change states, or if there's a change in the state law where they're located. So any sort of change, whether it be their movement or a change in the law that then that you're able to determine that it no longer meets state educational requirements, then you make sure that those notifications are going out, and that you are not serving students in those states. Let's say if there's a change of law, that you're not going to serve any more students in that state, but you can continue to serve the student who has begun.
And let's be student-centered. And you know, there's a good, nice regulatory answer there that she gave. But if your program's not going to serve that student who's now moved to New York and that they want to stay there in New York, you can, you can continue to serve them. But you know, you also want to look at, you know, are there reciprocity agreements or professional reciprocity agreements that will help them? That could be a thing. And the other is that is it time to help that student find another program?
Yeah. The other question too you might ask is, do you plan to go back to Michigan to work? Right? I mean, maybe mom and dad are moving to New York, and that's why they're moving to New York, but their plan is to come back to Michigan where they grew up, and that's actually where they want to seek employment, and that's where that attestation could come in.
Or they live in New York and they're going to work in New Jersey.
Yeah. And it works there. Yeah.
And you're good in New Jersey. Right?
Absolutely. Absolutely. It's an opportunity for a conversation for sure. Another interesting question. You know, somebody said, look, we have an accounting program. And we talk about accounting and engineering being kind of tricky. And they said, we advertise this bachelor's degree in accounting as a foundation foundational concept, right? But you can't be a CPA, we don't think, in our state or any other state, unless after you graduate, you do additional coursework beyond the BA. So, while we think our BA is satisfying many of the educational requirements in most states and is probably similar, I'm going to assume, to a lot of BAs, we also think that in almost every state, before you could actually become a CPA, you would have to do some additional coursework. So professional licensure program, not a professional licensure program. What do you guys think?
Good, Cheryl. See.
Well, I would say that's a very good question, and brings you right through the flow chart that we were discussing earlier. And so they're going to have to make those kinds of decisions about the program and why. I think they need to be transparent, but I think that when it's not designed to be able to provide the person the ability to sit for the CPA exam without extra courses. So completion of the program does not get them to complete all of the elements to be able to sit for the exam.
That's right. I think there's a couple of things there, right? I mean, the first is you're not representing that your program satisfies all the educational requirements, for starters. Secondly, as someone actually pointed out in the Q&A, you can be an accountant without being a CPA. So are you really, is your program specifically designed for people to be a CPA, or is the occupation accountant? In which case, can you practice in that profession is it not required? In other words, that certification, I guess the way to say it is, it doesn't sound like that certification is required for you to practice in the occupation. But that's exactly right. I think it goes back to that first box and being really thoughtful about it and documenting your decision and talking with counsel and all of that kind of stuff. So one person asked, and I'll just, the way they said it is they said, oh, our post-baccalaureate certification program's covered. And I'll just say more generally, if it's Title IV, are there any limitations based on the type of program? And I'll throw that out to you guys.
Can you repeat that again?
Yeah, let me ask the question this way. If it's a Title IV eligible program, does it matter what kind of program it is, like credential level?
Yeah, because there are post-baccalaureate programs that are entry level sort of programs. So I'm thinking of things like, there's a lot of things in the medical area where you have to go beyond, or and even the PharmD or something like that, or there's other sorts of programs where you need additional things. And if that is the entry level requirement and it's beyond the baccalaureate, and the state says, yes, you need to have this that's beyond the baccalaureate, then it's up to the state again, that they're the ones that get to say for that profession that this is the requirement. And again, if you're doing Title IV, you have to follow those Title IV rules for a professional licensure program.
Right. Agree.
I agree. Yeah. Required for employment in the occupation is the key, not the credential level.
Exactly right. So we're almost out of time, but I have one more question. So I got a lot of questions along this line. I think there's still a lot of confusion. I will say, I'm going to ask the question, but for those of you who had this question, I do think if you go back and re-listen, by the way, all of our webinars are free and posted on our YouTube site, on Thompson Coburn's YouTube site within usually a day. So you can go back and re-listen to these at your convenience. And I think you'll find a lot of these answers in the webinar. But here's the question. We've been told that we can craft our location policy to state that, and I'm going to pick a little on the questioner here with no disrespect intended, that our on-ground students could be considered residents of our home campus. And so, Russ, I'm going to direct this one to you first, maybe to comment on the use of the term residents, and then also to just talk about, where on-ground students are located.
Okay. Yeah, we really hit on residents because, we really want to stay away from the word residents because it has so many meanings in higher education and in the state in general, because you can be a resident and be able to vote, but not be a resident for the purpose of getting tuition purposes, in-state tuition, that those two things can happen at once. So it creates all sorts of things. So all these rules are about the location of the student, where they're going to be. And so, so if you have on-ground students that are at the main, or in the main campus is what it would be, yes, they would be located at the main campus, if that's the question. I'm not quite sure where you're getting.
Yeah, that's the question. That's the question. I just wanted to hammer that home, that the law prior to Russ's NEGREG in 2019 did use the term residence, and it was very confusing, create a lot of problems. And one of the really positive things that you guys did, Russ, was change that to location. So the question here is not the residency status of the students, it's where the student's going to be physically located.
And Russ was a pain in the neck in the 29 things about getting everything changed to location. Yes, thank you.
Absolutely. No, and Russ, we appreciate that. That was a huge improvement. That was a huge improvement. So I think we're about to be cut off. I just want to thank everybody for tuning in. There was so much here to cover, and we really appreciate it. Again, the slides are available. If you can't find them or you have problems with the links, just let us know. The webinar is recorded and will be on our YouTube channel as well. And Russ, Cheryl, if you guys want to put it somewhere, obviously we can make that happen. And I want to just thank Russ and Cheryl and Katie again for making time and wading through what's still a pretty sticky and difficult topic. And we know there were lots and lots of questions. We tried to anticipate and answer as many as we could. Look for the department's Q&A. I think they know also that there are a lot of questions out there. Look for further materials from Russ and Cheryl. Follow their Frontiers blog and keep a lookout for us as well. And we'll try to get, as soon as we have answers or we see the department putting out answers, we'll try to get folks some updates. Other than that, I will say thank you again. Please do the post-closing survey, and we'll see you next time. Bye all.
Thank you.
Thank you.
Bye, thanks.